Mark, right? Hi, how you doing? Mark, I appreciate that you're a professor at university and that you've been teaching a lot of people about law, right? But the whole time, right, since 2013, I have been reading and researching in law myself in my own capacity at home. And now I'm sort of semi-retired, so I haven't been doing anything else, right? The first part of my learning and study was actually in practice out on the field, right? Actually, supposedly using the rights, constitutional rights and law, right? Now, Mark, there are a few things that I've got to say. And firstly, right, the book on public law, right, that you've edited, which clearly you say in that book that somehow you believe that the EU law has somehow diminished or affected constitutional rights, which it cannot be and is not the case with Parliament and the usage of Parliament. And I'll explain why that is, right? So, and you've also done a book on constitutional law, right? And I can't actually get hold of it because you've got to pay for it, but there'll probably be some website that I can read it on for free somewhere, right? You're trying to make out in this book, right? This is the synopsis, right? Or the summary, that the Supreme Court has been making certain orders and judgment which have been affecting and controlling the constitutional law, right? That's what it effectively says here, right? Whether you disagree with me on that or not. This is what it says. It's talking about the Supreme Court, right? In relation to constitutional law, right? Now, Mark, there are a lot of books that need to be read about constitutional law, right? And the first book that I ever should have found when I very first started reading, because the first book I ever found was Peter Ackroyd, right? And he just basically gives a briefing of historical events, but it's just whatever they had in the library at the time. So I started off with Peter Ackroyd. It wasn't a very good place to start off, but he talked about the Civil War and various committees in Parliament and petitioning, right? So it did have a little bit about it. Now, I wasn't really on the ball back then and knowing where to research and where to look to get my books. I should have done a university course in constitutional law, but if I had done, I don't think that you're actually teaching what needs to be taught at all. In fact, you're teaching it from a position. You're not teaching it from an impartial position at all. It's being taught from an anti-constitutional law side and from a criticism and even possibly a challenge to the constitutional law, right? Right. This book here, right? So this guy here, this liberal, right? This guy's written a book and he wasn't fully in the position to openly validate and advocate the full extent of these political rights. Anyway, very few people are reluctant to, although there are actually lots of modern enactments of common law which fully support pretty much everything in the common law. So I don't really know where this challenge is coming from. Because, for example, in the Control of Advertisements 2007, in Class F, in Schedule 1, it says you can use any enactment, right? So you've got the common law that actually says you can use any enactment and its provisions. So if it's saying you can directly use the 1688 Bill of Rights, right to petition, and that the provisions are that all prosecutions against you are illegal, right, when you're using advertisements, then you can't be prosecuted because that's a direct application of any enactment of law which exists and is in force. And some acts of law say that you can't use privileges, like the Bankruptcy Act says that in that act you can't use privileges. Now, I think your basis and your principle is around this whole idea that when you've got the law and you go into a court, you can argue things, right? You're allowed to argue and make points, and then it's up to a judge or a jury to decide. But that's if you can hear the case in the first place. That's if the case can be heard in that court. There's something called petition for leave of court, which you can check it up, which they made an amendment in the 1980s to say that, in 1980, to say that they allowed certain things to be heard in a court, like committee reports, which previously needed leave to hear, right? Now, when you're first caught, when you're court of cause, the court what you start your case in is Parliament, it has jurisdiction over the matters and proceedings and everything that you're doing under that jurisdiction, including your mesny processes, right? You can't argue with the Supreme Court about that, because in the Bill of Rights, matters and causes to Parliament aren't under the King's Bench, right? And this book here, right, by Anson, Sir William R. Anson, right? This book by Sir William R. Anson, he writes, he wants to do a better book than Edward Coke, because Edward Coke does a book which covers the jurisdiction of the courts, the different jurisdictions, and he makes it clear that Parliament's jurisdiction is separate from the other courts, right? And then William Prynne actually calls out, you've got to know this, you can't not know this, right? You must know this already. William Prynne, right, called out Edward Coke and heavily criticised him for making errors in his book, mistakes, right? And that's actually what I'm doing now to you. I'm being like William Prynne was to Edward Coke, and I'm calling you out for mistakes and errors in your book, right? Now, Edward Coke did correct some of his errors, right? Coke corrected his errors, but he made them. But he was a Speaker of Parliament. He was a Speaker of Parliament and he made errors in his book, but he corrected them. And William Prynne had his ears chopped off, Mark, right? William Prynne, for the sake of law, and this is someone who studied at Lincoln's Inn, right? And he was like, as good as lawyer as anyone at the time. He was a meticulous student, scholar, and lawyer. He went through the entire rolls of Parliament, through all the laws of England. He was determined to find out the exact origins of parliaments, how they were formed, how they were called, where they had these grand councils and grand meetings, and the first parliaments were mainly only the prelates, right, and abbots and bishops, and the grand councils had the equivalent of the lords and the knights, right, and then they gradually formed the parliament, right? William Prynne was obsessed with finding out what is the actual origin of the Parliament itself and the word Parliament, and when did they start using the word? What even is the Parliament, right? Now, Prynne corrected, like I've just said, corrected a lot of things. And John Hatzel, who actually worked in Parliament, Hatzel actually is is what you call a true impartial person, a true unbiased person, because John Hatzel actually, he gives credit where it's due. He gives credit to William Prynne, he gives credit to Sir Edward Coke, and he gives credit to other writers, right? But what this even Anson here, right? He's not a great fan of the right to petition. He's not, even though he's a liberal, he's not a great fan of it, but he's got to be honest and tell the truth. So he gives a accurate, if not favourable, account to the full extent of the right to petition. But in this series, right, what he does do in this series, he writes out an absolutely thorough, detailed and clear account at the time, right, when he wrote these books. When he wrote these books out, right, Customs and Laws of the Constitution, right, as it was towards the end of the 1800s, right, he explains the full history and current state of the courts, and he clearly describes how because they had the Supreme Court, right, before the Constitutional Reform Act and before they abolished the House of Lords jurisdiction, Mark, right? You should know that, right? The Supreme Court at the time, right? The King's Bench, Westminster, was all merged into the Supreme Court. And now the Supreme Court has taken on the appealite jurisdiction of the House of Lords, Mark. The Constitutional Reform Act 2005, right, has only taken on the appealite jurisdiction of the House of Lords. If your origin of cause started out in the other courts, if your origin of cause starts out in any of the courts, you no longer have a right to appeal to the House of Lords. For appeals in existing cases which start in other courts, not if your cause starts in the House of Commons, Mark. If your cause starts in the House of Commons, you don't appeal it to the Supreme Court, right? And the House of Lords still actually, you can still petition the House of Lords through Standing Order 75, right? You can still have the House of Lords as a origin of cause, right? And through the House of Commons, it's still possible to get impeachments if you can get them to accept the petition and vote it through, right? Because that's how it goes through to the House of Lords, because it's a Parliament's own jurisdiction. And when that jurisdiction is encroached on illegally, in the current Erskine May books now, they're publishing them. Contempt against petitioners, right? Contempt against petitioners and others soliciting business in order to Parliament, right? If anyone's arrested, or if the jurisdiction is encroached in, it's contempt. And that includes, if you read the Journals of Parliament, it's any officer, any plaintiff, any Crown prosecutor or a judge. But Parliament aren't calling people in. They're not calling the police in on contempt. They're not calling the CPS in contempt. And they're not calling the judges in contempt because they're not holding contempt proceedings. They're refusing to do it. It's there. They can do it. The Culture, Media and Sport committee is supposed to be set up to deal with contempt. They're not calling YouTube in when anyone gets their videos or channels taken down, right? They're not using it. There's no punishment, deterrent, or enforcement against the authorities. They're just not doing it. When it's a gap. It's meant to exist, right? Now, this is the problem. You're trying to make out that the Supreme Court, right, which is it's taken on the King's Bench, right, illegal prosecutions by the King's Bench for matters and causes decidable only by Parliament. It's decidable only by Parliament when that's the court of origin, right? Because that's where the jurisdiction is. Public petitions to Parliament, Mark, right? And private bills are under Parliament's jurisdiction, not the Supreme Court, because the Supreme Court is still only a public authority, right? Now, where does it say that in the Human Rights Act? Mark, right? In the Human Rights Act 1998, Mark, right? In the Human Rights Act 1998, Mark, right? In Section 6, it's about the public authorities and their jurisdiction. The police are a public authority. They have the jurisdiction of local magistrates' courts and Crown courts. That's where they're allowed to do their messy processes. And if you get prosecuted for a crime in one jurisdiction, they send the police to go and get you and deliver you into that jurisdiction in custody, right? Right? They can do that. There's some question about that over the Scottish border, which I've been pressing them on, right? Because they seem to be doing it for criminal driving cases, but they don't want to do it for civil cases, go and grab people because they say that it's not the jurisdiction of that court, right? So there's some questions about that. Now, look, the public authorities, like the Crown Prosecution Service and the police, the courts are a public authority. Section 6 in the Human Rights Act 1998, Mark, right, Section 6.6 is Parliament, and laying bills and the processes of laying bills, the proceedings of laying a bill to Parliament. But do you even know what a bill is? You think that's only if someone proposes legislation. If you actually read all of these constitutional law books and the history of England books, right, it clearly states that in the history of Parliament, in the rolls of Parliament, and in the records of Parliament, the word bill is actually interchangeable with petition, right? It's synonymous. The word bill is, in the entire history of England, synonymous with petition, right? So it is a fact. And it's not actually a fact to argue in the Supreme Court, because it's not actually the Supreme Court's jurisdiction. They've got appeal-like jurisdiction from existing cases in other courts, but not Parliament, because they've absorbed the King's Bench. The King's Bench cannot hear matters and causes to Parliament, which start in Parliament. That's a constitutional right. The Supreme Court have not been given that power through the Constitutional Reform Act 2005. They've only been given appeal-like jurisdiction, Mark. They haven't been given jurisdiction to hear causes and matters to Parliament, which is like what is Nigel Farage doing now with his challenge for, Parliament or the Secretary of State calling off the local elections. The courts could never hear elections until 1868, when they were given special jurisdiction in Acts to hear and determine elections, the outcome of the election, only the outcome of the election. The courts have only been given the jurisdiction and authority, Mark, to hear the outcome of elections, not whether you can or cannot have an election on, right? And that's what Nigel Farage is doing, but Nigel Farage hasn't got a clue what he's doing. He cheated his election with the Talking Pints programme, and no one challenged it because no one had £5,000 to put up the deposit and no one was reading the election law. So he got away with cheating with Talking Pints, and Parliament won't even hear any petitions under the controverted elections rule, which exists in Erskine May, which they won't let us run any petitions for that. We're being obstructed, right? So the Human Rights Act, what I'm saying, Mark, is this, right? The Human Rights Act 1998 distinguishes between the public authorities, of which the courts are a public authority, and Parliament, which is not Parliament is not the public authorities. Because it says in 6.6 that a process of it means that when you are in the messy processes, right, of introducing and pursuing a bill to Parliament, which clearly also must be a petition as well, include petitioning Parliament, right? It is a distinctly separate process and jurisdiction from the public authorities, Mark, without question. So the EU law has not affected or diminished Parliament as your origin of cause. Your origin of starting the cause is not by the courts or public authorities, Mark. It isn't. And this is another thing but with the EU law, right? All the articles in the EU law, the right to freedom of speech, right to privacy, blah, blah, blah. The government are breaking all those laws, right to privacy. When they introduce the digital eye in the TV, where's the right to privacy in your own home? Who's been challenging on that, right? But look, all this law, right to remedy, right? So your belief, right, with most of these common lawyers and modern lawyers, public law and civil law, like, when you have an accident and sue someone or trip on the pavement to the government, right, is that if any of these protesters, and they're trying to call them general political protesting or like, widespread political protesting, which I don't think that you can have such a thing, right? But that's a separate argument, right? If any of these protesters, right, damage something or harm someone or injure them, right, the current belief that you're trying to peddle, right, on everyone is that the other party has got a legal right to have an action in court or a civil remedy, right? Because they've been injured or harmed, right? But you need to get this clear before we go into the modern part of it, right? The privileges were the usage of Parliament as a court through proceedings and its jurisdiction, which is not to be encroached on by the other courts, right? That's a different aspect of privilege, as you should know, than the privilege when it's used when any person has done something that is not claimed as an original cause to Parliament and through processes, which means that MPs who are working in Parliament and elected to Parliament, or their staff or servants, if they committed a crime in their normal private life or owed someone money in their normal private life, the privilege was protecting them, right, for the duration of Parliament. But that was problematic, right? Because people couldn't, get monies, get compensated. So all that privilege did eventually was stop them from being arrested or put in prison so they could do their job and serve. But those proceedings could actually still be brought and proceeded in, right? While Parliament was in session, people could bring legal cases, but the other people were free not to be under arrest while it was going on, right? And you could still therefore claim money back from servants and so forth, right? Now, that's like when you were getting into this Mike Amesbury case, right? When Mike Amesbury punched someone, and Dan Norris and Patrick Spence MPs, they were accused of sexual offences, right? And that aspect of privilege is in a private capacity. Are they protected from arrest to do their job while the proceedings go and not be arrested until after Parliament session? And then you're getting into like MP recall and democratic accountability and whether people want to re-elect them. And then they would, have the right to go back in Parliament again. But I don't know if you can stand again if you've got a criminal offence, right? But this is the thing. It was meant to be it was a postponement. The privilege of Parliament has only ever postponed proceedings for people serving so they can serve, right? It's not been a complete and total protection permanently, which is a totally different to what we're talking about when we're using Parliament, right? Which is like when the police use their capacity as a constable, right? When they use their capacity as a constable, they're allowed to do certain things, but that's under that law in that jurisdiction. When a police kicks a door down, or when a police officer's chasing after someone, if it would hinder the vehicle for the purpose of which it was being used, the speed limit doesn't have to be observed. That's under law, but it's still under the jurisdiction of that court which they're bringing the case to, right? And if someone wants to sue the police, for their door or whatever, but the police officer, that's not a crime. It removes him from being a criminal, right? Removes him from being a criminal. But if someone wants to challenge, the police on that, the law protects the police officer, right? But with the usage of Parliament, there isn't actually really much law around it, because it's not, the proceedings are not under common law. And you're trying to say, well, how does common law affect political rights? But it doesn't affect it at all, because when you are engaged in a political cause to Parliament, the law that governs your actions and the law that governs your processes, similarly to the police, right? But in civil process to Parliament, isn't governed by the common law. It's governed by the law of Parliament, which actually is a different law. And if anyone does challenge that law, the courts have got to get a petition for leave of court to mention it. And they were meant to have done, they always have, except for the House of Lords, they didn't have to get it because there's a certain jurisdiction to do with the Lords for writ of error and appeal and bill of exception, like in the Statute of Westminster II and things like that, right? For the House of Commons, it needs to get voted through the Commons into the Lords if you're doing a legal action. The courts uniformly never really followed that rule for petition of leave of court. They were actually notorious for breaking that rule and not following it. It's still a rule, it's still a law, but they don't use it, hardly, because they don't know about it. And this is the thing. There was some exceptions to that law in 1980. They said that the courts don't need to get permission to look at committee reports and committee papers. They can use them, right, to make determinations on or to help guide them. That's not giving them permission to hear the cause. They can't hear the cause and they can't talk about the original cause because they're not there to judge it or anything you did pursuing it because it's not under their jurisdiction. And this is what starts with Edward Coke, but is confirmed and affirmed by multiple writers like Prynne and John Hatzel and onwards. And that's not changed. It has not changed. People just haven't learned it and you haven't been teaching them it. You haven't been teaching them that law. And it's not actually under the jurisdiction of the Supreme Court. They might think it is. But what about Jeremy Johnson, right? Jeremy Johnson went into court at Southwark Crown Court with Lord Hanningfield, right, in front of Alistair McReef, R.I.P., now deceased, right? Alistair McReef has passed away. Jeremy Johnson brought a 6-page paper, right? A 6-page paper into court claiming that Hanningfield has got privileges, right? This is after the expenses scandal, right? But this is the thing. What was that case about? It was a criminal charge, but it was about owing money, right? That he was a fraud, right? He scammed money out of the government that he didn't pay for his expenses, but they wanted to prosecute him criminally, right? Now, this is the thing. In the 1689 Claim of Right Act, it says you can't use privileges for a civil debt to other persons, right? And that is manifested through those Parliamentary Privileges Acts. And that's why that they can have proceedings, right, while Parliament's on, or it's just that people weren't subject to being arrested, right? It was they could have their personal liberty and freedom to do their job, but the other claimant still could have a civil claim and collect monies back from them, right? Now, the thing is that, you know, with Hanningfield, right, it's not just any other crime, right? It's a crime which involves money and taking or owing money to the government, right? Now, this is the thing. What Jeremy Johnson did not write in his paper is he did not write anything about the Bankruptcy Acts, which actually have got special law that if anyone who's got privilege of Parliament, like, you know, is about to go bankrupt and, you know, they're trying to hide their monies or deceive what monies they have or don't have, right, to the government, they're not allowed to use the privilege, right? Now, there's a intimate connection between that Bankruptcy Act and the fact that you're not allowed to use it for privilege, and the fact in the 1689 Claim of Right Act you can't use privilege protections for civil debt. And also in various other riot acts and the Tumultuous Petitioning Act and so forth, which developed that like in the malicious damage, that if buildings get damaged and so forth like that, there's still a right of claim for loss or damages. Now, but this is the thing. Look, they're trying to say that you're not criminally liable if you're doing something on process, like the police. The whole point of the legislation around the activities of the police is that they're not criminally liable for what they do because they're doing it for a just cause. And that's manifested through multiple acts which govern what the police can and can't do, which a normal person can't do, kick someone's door in, right, etc., because otherwise they've damaged it, right? Now, if you want to treat it as a crime or do you want to treat it as a civil debt, like you owe us money, right? It depends how you want to approach it. But this is the thing. When you're using Parliament, right, and when you are actually doing that, it is not under the jurisdiction of the courts, right? And you aren't criminally liable for what you do. You're only civilly liable, and not through the jurisdiction of the courts civilly liable. You're only going to be civilly liable through the law of Parliament. So that means someone can, if they're going to bring a claim of damages, then they should do it to Parliament because it is under Parliament's jurisdiction. And then it's under the law of Parliament, not the common law, but you can still make a claim. That's why you petition Parliament. If someone's doing a civil mesne process and something gets damaged and the person says, my door's got broken, I want the money for it from them, then they can petition Parliament. And they can say, so-and-so broke my door in, I want compensation. That's your that's the court who are dealing with the matter, whose jurisdiction it's under, Mark. Now, the other basis and principle in this is you're saying, oh, no, people have got a right to a remedy or whatever. Look, right, if you commit a crime, a criminal offence, right, the victim, right, the victim isn't actually the claimant. They're not the claimant. So under EU law, if you do anything to anyone under EU law, you've got a right of action. Everyone's got... Look, right, when you commit a crime, right, it is you versus the crown, the king, right? You broke the king's peace, right? You aren't in court because of the victim, right? The king has got you in court because you broke the king's peace, right? You're answering to the king, right? Not the victim. It's not you versus the victim. It's you versus crown, versus Regina, versus king. Now, when you are in civil mesne process, or pursuing a matter or cause to Parliament, right, you've got cause of action and everything you're doing is for cause of action. This is the right to petition the king and all prosecutions against you are illegal. Like when you're catching a highwayman and you are pardoned for all your offences, which is supposedly what all the police legislation is meant to be for, to allow the police officers to do things in order to catch criminals because they're naughty, right? He's in pursuit, right? When you're in pursuit, right, you're allowed to do certain things because you've got a greater cause. But even if you do break a law, which is a criminal act, it's the king. The victim is not coming after you for damages or because they've got a right to a remedy, because they're not fucking prosecuting you. The king is. You broke the king's peace, right? In EU law, when you've got a right to a remedy against another person, is Smith versus Smith, Johnson versus Johnson, Biggins versus Biggleswade, right? Because you're the plaintiff and you've got a right to a remedy. You are the plaintiff. You got a right to a cause, which is why You can't use privileges for civil debt because people's servants were using it and abusing it. They've always had that. It's actually got sweet FA, nothing to do with EU law. Absolutely nothing, Mark. It has got absolutely nothing, sweet FA, to do with EU law. Are Europe the king? Are Europe the king? The victim is not fucking prosecuting you when you break the law, Mark. If you break the law, right, the victim is not prosecuting you. They aren't bringing a case. They don't have a right to remedy because they're not the fucking plaintiff, Mark. The king is the king. And when you're bringing a case, when you are bringing a case to the court, right, you've already got a fucking case with the king between you and the kings. The king's hearing the case between you and the plaintiff. But when you're doing it to Parliament, right, you are the plaintiffs when you go to Parliament against the government. And then everyone else has got the right to oppose you in what you're doing in Parliament. In Parliament. Under the law of Parliament. It has not got anything to do with the Supreme Court. And I don't know where they've got the justices haven't got a clue what the fuck they're doing. Because this is the thing with Nigel Farage now. Jeremy Johnson wasn't even right in his own paper because he's excluded the fact that in all those Parliamentary Privileges Acts, it says that you cannot use it to avoid the King's debt, right? It says that clearly, King's debt, right? Money. But that's not against the King's peace, right? That's debt money. You can't, and that's why Lord Hanningfield shouldn't really have been using privilege, but with the Lord Hanningfield case, they should have pursued him to collect the monies, right? Civilly. I don't know why they did it criminally. They should have done it civilly. And, the argument with that case is because it was a fraud and finance and money issue, is it the same principle as in the Bankruptcy Act? Well, the thing is that they should have just they should have pursued him in a civil claim that he owed money and that they cheated him out of the money, right? I don't even know why they pursued him through criminal charges anyway to start with, because once they proved it civilly that he owed the money and that if he, they could have recovered the money. And then you want to say, well, is he accountable criminally or not? Well, actually, why don't they impeach him? They've got impeachment. He can be impeached in Parliament. The whole criminal court case was it's erroneous, the whole thing. They went about it erroneously, and this is like, the newspapers, the Sun and the Mirror or whatever, who investigated it, whichever newspapers it was, badgered him and badgered the government, and they had all these, the uproar in Parliament and all these privileges reports. They're not even doing those privileges reports correctly in Parliament. They're lying, Mark, right? And they're saying that it was never used, privilege was never used in criminal matters, which is a complete and total lie. It was used in criminal matters. It says in the short Parliament journals, which I've submitted a complaint to Parliament about by petition, by John Pym, misdemeanors, it is used. And it was actually, in what context? In the context of members and their servants in a private capacity, could it be used for misdemeanors to postpone the proceedings, but not felony? Well, yes, it could. There were hardly any records on there because it was just a matter of timing, waiting until the end of sessions before they brought their proceedings. That's all. It was a postponement. It wasn't actually that much of a big deal. But when it's actually foremost in the process, we're talking about things like ordering a sergeant at arms to go arrest someone, right? when Parliament ordered the Sergeant at Arms to go arrest someone, it's under the authority and jurisdiction of Parliament. And there were already a lot of conflicts between that the House of Lords and Parliament already in the journals and history book. You know, they had a big conference about it. And that doesn't really affect or impact the Supreme Court, because for anything except if it's not appeal-like jurisdiction, if you're not appealing a cause which started in the lower courts, right? For the Supreme Court is meant to be, it's the same basis and principle as the King's Bench, right? Which says, because it's absorbed the King's Bench, illegal prosecutions by the King's Bench for matters and causes in Parliament, which are your original cause. It's your origin of cause is Parliament, which is public petitions and private and public bills and other business to the House of Commons, Mark. There is actually nothing that confusing about it. I don't think that you've been reading all of the proper books properly and all of the acts of law, like the Tumultuous Petitioning Act and the Riot Act. Under the Riot Act, you've got to be riotously illegally assembled and riotously assembled and tumultuously assembled as well, which means that if you had a court order for your petition, you can't actually be prosecuted under the Riot Act. Or if you had under 20 people and you had a petition to Parliament, you didn't need a court order, you cannot be tumultuously assembled if you're under 20 people if you've got a case to Parliament. So it doesn't matter if you had over 12 people on the Riot Act, because you're never tumultuously assembled. And you're not unlawfully assembled. And they abolished the Tumultuous Petitioning Act in 1986, right? So there's no limit on how many... You don't need a court order anymore to use Parliament. You don't need permission or consent to usage of Parliament, right? And the Public Order Act was in effect at the same time as that Tumultuous Petitioning Act, and the Public Order Act's based on the same principles as the Riot Act, right? And that's why the Criminal Damage Act is privileged on public land and property under lawful excuse. You can use the privilege of Parliament in the Criminal Damage Act under lawful excuse on private land and on public land and public property, which is in public. And that's why the 2007 Control of Advertisements has got Class F, which is a complete exemption from defacement and damage in public, on public land and public property, because you can use any enactment. So you can apply the 1688 Bill of Rights directly, right? Or any of those privileges of Parliament Acts or whatever. It removes it also. The police also are in great error. They love to bring criminal damage charges. The defacement is removed from criminal damage. If there's any instance of defacement, you aren't allowed to class it, describe it, or attempt to qualify it as criminal damage. They made it so no surface damage qualifies for criminal damage anymore, right? Are you teaching people that? It's all fines, and it's all fines with specific exemption, right? And it has to be compatible with the 2007 Control of Advertisements for the attachment of things on surfaces and using screws and things into things. That's why you can use any enactment in the Act, and that's why you've got lawful excuse in the Criminal Damage Act 1971. Anyway, they're all compatible with each other. And then you've got, what has the advertisement got on it? What is the advertisement advertising? Then you've got all these, you've got the Obscene Publications Act, which is for public good. It's always for the public good when you're doing a petition and people are signing it, right? Because the public say that it's for their good, that it's the public cause on behalf of the public. All these enactments, and this is where all the modern law is made to accommodate for privileges, but only to make it easier to interpret it. It's not governing it. That all those clauses in those Act, Mark, aren't governing parliamentary causes in common law. All they're doing is facilitating for and providing for them. But it doesn't actually matter if they do or they don't. It's just to help clarify. When you're using the privilege of Parliament, right, it's a jurisdiction thing whether the court can hear it or not. It doesn't matter what the law is. It just helps to clarify it in the law. You've got neutral acts, right? Are you teaching people about neutral acts, right, when they don't say anything about privilege? If it doesn't say anything about privilege, then you can use it for privilege. If it's privilege compatible, the Criminal Damage Act is privilege compatible. The Control of Advertisements 2007 is privilege compatible. The Copyright Act 1911 is privilege compatible in Section 20, right? And also, the Obscene Publications Act is privilege compatible. The Bankruptcy Act is not privilege compatible. It explicitly says you can't use it, Mark, right? So any other act that explicitly doesn't say you can't use it is neutral, right? Because it doesn't say you can or can't use it. But it doesn't really matter because it's a jurisdiction. It's not actually... It's not about the common law or not, because you're not actually making use of common law. When the police, right, chase a criminal, right, they're governed by common law, and there are common law offences. And, if it would hinder the purpose of which the vehicle is being used, then the speed limit doesn't have to be observed. That's common law to make it so the police does not commit an offence if he is pursuing a criminal. But, for the purpose, what purpose is it being used? It doesn't say, right? This is the thing. No one argues that in court hardly. But even so, the police officer can only use a vehicle for the purpose of which it's being used in his own jurisdiction, right? Because police are only sworn in and have a jurisdiction for an area, right? When it's, when there's someone committing an offence in another area, they've got to be sent over and they're out of jurisdiction. And there are loads of arguments about, well, what if you have police officers working in different areas, right? We can argue that, we sent some police officers from Lincolnshire to London, right? Are they working under that force or not? There are arguments about that, but still, they're still only the public authorities, and they're still only in fact, you've actually got to get permission. You've got to get a permission for a case to be heard in a different court, in a different jurisdiction. You've got to apply for permission, and they've got to grant it, right? They can't actually just hear it straight away. They've got to have permission, right? That is area jurisdiction. We're talking about hierarchical jurisdiction. And, all these cases that you're talking about, the Supreme Court, they're just wrong. I know they're wrong because Jeremy Johnson was wrong in his paper, but he got awarded, he got promoted and made into a justice, right, in the High Court, when his paper isn't correct. His 6-page paper on Lord Hanningfield, his attempt to defend him and use privilege, it's not a thorough claim and it's not a correct claim. And the fact is that they approved it. They actually, Alistair McReef approved that judgment, right? So therefore, that means that the Crown Prosecution Service were in contempt because they said that privileges applied, right? Mark, riddle me this. Why wasn't Patrick Gibbs called into Parliament for contempt? Why didn't Patrick Gibbs answer for contempt, right? This is the thing. If Jeremy Johnson had done that case properly, they would have called Patrick Gibbs, into the Parliament, into the House of Lords, and told him to drop the case, withdraw the charges, told the CPS to. That's how you're meant to do it. Check the journals, read the journals. That's what we're meant to be doing when we have got parliamentary causes or canvassing. And, you can read all about the parliamentary law of agency. Canvassing is something which qualifies for agency. Read the books of Ernest Arthur Jelf, like his, Illegal and Corrupt Practices Prevention Acts, right? The Corrupt and Illegal Practices Prevention Acts. Parliament are actually meant to be, if anyone's getting prosecuted illegally, which a lot of people are doing, Parliament's going to call them in and tell them to, firstly, withdraw the charges, drop the prosecution because it's illegal, right? And if they don't, then they get punished. But they're not doing that. They're not holding the proceedings. They're not holding them. So therefore, we've got no one's... That jurisdiction is not being enforced. There are no consequences to the police or authorities. And no one... So, and this is the thing. The victim is not prosecuting anyone, right? It is a breach of the King's peace that the King is prosecuting them. And that's where you're getting really misconstrued against the EU law. Nothing in the EU law whatsoever has made a victim of a crime in England, right, into a plaintiff, because they're not a plaintiff, because they aren't the claimant, right? They're a complaint. They complained to the King that the King's peace was broken, right? And the King punishes them for breaking his peace. And you've got it wrong, and you need to put it right. And what you're teaching them in the courts, right, in the universities, right, is wrong. The book on public law, right, on when it comes to constitutional law, is wrong. Now, I haven't read your new book yet, which is meant to be about constitutional law, but from what I've read on the synopsis of it and the summary, and even to raise the Supreme Court, right, is tosh. When it comes to petitioning Parliament and political rights, it's tosh. Now, if you trip up on a pavement, or if you're doing some sort of public speech for a charity, right, you're not using Parliament. If you're at a football match and you all got thrown off, right, and they all protest that they want to get back on again, right, and the police stop them, then the police can put a dispersal order. That's public law, right, and that is civil law. If everyone gets thrown off a football match and they want to get back on the pitch again, and the police put a dispersal order or whatever, that's got nothing to do with Parliament. It's not a cost to Parliament, right? And they've got a legal right, the right to protest, the right to free speech, etc., etc. EU law, right? Articles. It's not the law of Parliament, right? It's the public authorities. It's not pursuing a petition bill or other business to the House of Commons, which is 6.6 in the Human Rights Act, and is distinctly separate from the public authorities. Because that's just how it is. And you're trying to make out that, someone got headbutted and they've got a legal right to this or that. They ain't got a legal right to anything. They are complaining to the King, right, that someone broke the King's law, right? But they are not themselves the plaintiff. They aren't the legal plaintiff. They're not the legal claimant. If John Smith owes them money, they are. And you say then they got a right to a claim, right? Or etc. And when it comes to freedom of speech, etc., everyone has got the right to freedom of speech under Parliament's law, right? Everyone. So, and it's not actually under the common law of freedom of speech. It is, and that starts from Strode's Act. And if you want to say, well, what about EU? Look, right, they've got the European Parliament, and they've got the privileges of the European Parliament, and apparently all these European Parliament people are untouchable. So don't tell me that in Europe they've got all the privilege of Parliament, the European Parliament, Mark, right? I really don't know what these £87 or £90 books like brick thick, right, are teaching people. It's clear that you're still not teaching people about Parliament or the law of Parliament. And I've checked the coursework, right? It only looks like they're teaching people Edward Coke, William Prynne, John Hatzel on the legal history courses, right? In legal history and constitutional law courses. And your course isn't even... I don't even think your course is constitutional law. You're doing public law and civil law, and you're not teaching actually enough of the constitutional law in those courses. I don't think you're teaching people about the Tumultuous Petitioning Act. I don't think you're teaching them the Early Riot Act. I do not think you're teaching them like things like the Control of Advertisements 2007 or the, obscene publications, how it all ties into it and how the model of all that works. Nobody's actually written a book, right? There aren't any books that you can buy that actually teach you how it all works and fits together properly, right? That's what I'm working on. I'm working on that on my webpage now and on all my research and stuff, right? And I am pursuing a PhD or a professorship or any fellowship awards or pats on the back or Constitutional Society achievements or anything like that. I'm doing it because people are getting arrested illegally, right? And Parliament aren't doing anything about it. And none of the solicitors or barristers are doing it properly in the court, mainly because they're not even meant to be hearing it, right? And all it needs is, the causes aren't getting mentioned properly. Extinction Rebellion and Just Stop Oil and Insulate Britain they don't know how to tell the court what they're doing or what their cause is properly, and those causes aren't even allowed to be talked about, discussed or mentioned in the court. So it's a lack of education. They're not being educated. And then when they read these acts, like other Public Order Acts or whatever, they're not reading it with the full backstory, with the full basis, which is not about, you're not defending yourself. It's overriding objectives. When you go into a court, there are overriding objectives. The claim of petition for leave of court, right, and the right recognising the needs of other cases, that's what you've got, right, is an overriding objective. It's not a criminal defence, and you don't have to argue it or prove it to a jury. You only have to get it recognised by the court. And that's the type of thing the probation service do when they go in with your doctor's certificate and they say that you're ill and you're poorly, and they have to do it and they have to present it to the court. They're not defending you. It's not a defence, and they don't have to prove that medical certificate to a jury either, right? They have to get it recognised by the court, and it is not a defence. The rights of the defendant and the needs of other cases are this. It's a different species of document. The doctor's NHS certificate is not a defence or part of one, right? It is a rights claim which the Crown Prosecution Service and Probation Service have got an obligation to present, right, under your rights as a third party, not even as your own solicitor or part of your own defence, because they've got to do it. And that's the same for parliamentary causes. So we've got problems. And, I'm doing the William Prynne job here, right? I'm doing the William Prynne job, and I'm telling you, like you told Sir Edward Cook, right, that you made mistakes, and they need to be corrected in the books. And the Supreme Court... The Supreme Court can't be right or wrong because they don't have the jurisdiction to hear it. And this is the issue with Nigel Farage. Now, I don't even know why the Supreme Court took Nigel Farage's case on. They haven't got a clue what they're doing, the Supreme Court. They don't have a fucking clue what they're doing, the Supreme Court. They don't know. This is Jeremy Johnson. Jeremy Johnson. Have you seen his legal work? 6-page paper. Has he included everything that needs to be included? No. He's like, it's like pick and mix in a sweet shop. How can I get Lord Anningfield off, right? He hasn't done a proper job of it. He's a scam artist. He's a scammer. He's a con man. And now he's got promoted for it up to the Supreme Court. We've got criminals. Now, this is how can we get these people out? How can we get judges removed? You have to petition Parliament. You have to petition the House of Commons. You can't get justices removed in the Supreme Court, Mark. You can't go into the Supreme Court and get those justices removed for being criminal. You've got to petition Parliament to do it, Mark, to get them removed, or the JCIO. And the Judicial Conduct Investigation Office has got obligations through the Constitutional Reform Act. They can make representations to Parliament or, write to Parliament about anything to do with the judiciary. But they're not, are they? Because the Judicial Conduct Investigation Office are meant to actually act. They say, we can't act, we can't affect the case. Rubbish, right? When you have had a jurisdiction invaded on illegally, right, they are meant to act, because that's why people are supposed to get summoned to Parliament in contempt, because they're in contempt of Parliament, but they're not holding any hearings, right? The actual Judicial Conduct Investigation Office need to get called into Parliament. They're not getting called in. This is why we've got a petition Parliament, but they're fobbing us off with this e-petition service, which they're censoring, right? Mark, Parliament is corrupt, and you aren't helping us prove that. What you're doing instead is teaching barristers and solicitors who are just coming out of graduate university tosh. You're actually teaching them tosh. And I've got to tell you it's tosh that you're wrong and you need to correct it.